So this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. So put your questions in the comments now so that I may answer your questions. I have a good topic for you today. I am going to focus on parents getting their kids the green card. There's a lot of confusion, a lot of misinformation out there about how this works. So I want to give you a summary of all that is required to get the green card through a parent, what you should be doing, what you should not be doing. So tune in and then also put your questions in the comments. As soon as you know you have a question, put those questions in. So as soon as I finish talking about the topic I came to talk about, we'll jump straight into your questions. Now, getting the green card through a parent. I'm going to start with this. So I usually see, I'll get a call from someone and they will say that their parent is a citizen here and they're looking at getting the green card here. They overstayed their visa already, but now they just want to get started on getting the green card. And in some cases, it's fine. In others, I do have to break the bad news to them that it's not as straightforward as they think it's going to be. Now, if you have a US citizen or legal permanent resident parent here, you're going to have to be within a certain age group, or you're going to have to meet certain requirements to be able to continue to get the green card. So let me break this down into the categories, right? So that I can explain each category and what is going to be required for each category. I think that's going to be the easiest way to break this down for you. Now, if you are under 21 and you are unmarried and you have a U.S. citizen parent, then it means that you are considered the immediate relative of a US citizen. That puts you at a really good advantage because it means that you can stay here, whether you overstayed or not, you can stay here in the US and still complete the green card process through adjustment of status. As long as you can show that you entered the country with permission or you had some sort of inspection at the border, you can then move forward with adjustment of status. So that's for people who want to know, can I stay here and apply for the green card through the parent? If you are under 21 and unmarried, you've overstayed your visa, then it's still possible to go ahead and go through adjustment of status to get your work permit, your social security number, and then your green card. Now, if you came across the border without permission, then that's where it's not going to allow you to just simply do adjustment of status. If your parent is in the military, that may allow you to first get what's called parole in place. And that's like a permission after the fact to stay here, to be here in the US. Once you get that parole in place, now showing that you have permission to be here, you can then do adjustment of status, right? But if you don't have a parent who is in the military, you don't have a citizen parent who is in the military, then that, and you came across the border without permission or you came in without a visa, then at that point, you are going to have to go through a separate process, which I think I'll choose another day to talk about that other process. So, what I want to say here is if you're under 21, unmarried, and you can't show that you entered the country with some sort of visa or permission, there is a process for you. It's just not going to allow you to stay here for the entire process to complete the green card process. So that's the first category, right? If you're under 21, you're unmarried, um, and you have a U.S. citizen parent, then you can stay here and do adjustment of status. It's very likely that you'll qualify for that. Now, what if you are over 21? You're 21, now you're age 21 or over, and you are unmarried and you have a US citizen parent. Is that going to also and by the way, if you're under 21, you're unmarried, you have a citizen parent, then it means that your process is going to be through adjustment of status. If you're here in the US, it's going to be about 6 months to a little over a year. If you're outside of the US, you could be looking at about 2 years, for the entire process to go through. Now, I see here that Vibrant Ver has asked, what about over 21? So if you're age 21 and over and you have a US citizen parent, now I'm going to break this down into two categories, right? So if you're over 21 or over, you have a US citizen parent, and say you're here on your visa and your visa has not expired, you have not overstayed the time that you were given, and then you get notification from the National Visa Center because you have a pending petition that says we are ready to process your application to get the immigrant visa. Can you adjust status at that point? It's very likely that you will be able to adjust status while being here in the US, right, on your visa. But you have to make sure that this application for adjustment of status goes in before you overstay. If you overstay, you will no longer qualify for adjustment of status. So at this point, if you're 21 or over, you always have to make sure that if you're filing an adjustment of status application, that you're in status. If you're out of status, if you've overstayed the time that the permission that you are given to stay here, it's not going to work, right? Now, if you have already overstayed, it doesn't mean that you are disqualified from getting the green card, but you will not qualify for adjustment of status. So if you're 21 or over, you've already overstayed, you have a US citizen parent, you will not qualify for adjustment of status. Also, keep in mind that once you are 21 or over and your parent files for you, either your US citizen or your permanent resident parent files for you, it's a 5 to 7 year process. So there's no way that you're going to see that green card any earlier than that 5 to 7 year timeline. So there's no quick way to do this because right now the wait list is 5 to 7 years long. So the point of this is if you are approaching 21 years old and you have a US citizen or a legal permanent resident parent, get those papers in. Because then it could assist you could make your process faster, especially if your parent is a US citizen. There is the misconception that it's 18. Like once you get past the age, once you get to 18 years old, you're no longer considered a child. Not true. Under immigration, it's 21. So as long as you're under 21 with a US citizen parent, that means your process can still move faster. So don't let your age, that 21 year, because once you hit 21, it's going to turn into a 5 to 7 year process. Now, if you have, so I already said, if you're 21 or over, if you overstay, the adjustment of status is not going to be for you. It's going to be a different process. And since I am talking about this different process, I'll cover this on Monday about what that other process is. It's called a waiver process where you have to ask for forgiveness for the overstay. So I'll talk about that waiver process on Monday. But at this point, that's the process you're going to have to go through. Now, if you have a US citizen, if you're under 21 and you have a green card holder parent, this is also going to be explained in two ways. If you are here and right now, it's current, meaning that there's no wait list right now for children who are under 21 and unmarried of green card holders. So that means if you're here, you get news that your petition has been approved or you're here on current status and you want to move forward with your green card process, you don't even have to wait for the I-130 to be approved. You can file everything at one time to get adjustment of status. But if you're here on your visa with a green card holder parent, and it is still current, you can apply for adjustment of status, similar to being the son or daughter under 21 of a US citizen, because right now there's no wait list. So that would be something. But one thing you can't do as the son or daughter who's under 21 of a green card holder is overstay. So that's the difference between being the son or daughter under 21 of a citizen versus the son or daughter under 21 of a resident, is that the son or daughter of a US citizen who is under 21 and unmarried, they can still end up overstaying their visa and still qualifying for adjustment of status. However, when it comes on to the son or daughter under 21 and unmarried of a green card holder, they cannot afford to do that. You have to make sure that that application for adjustment of status goes in before you overstay your time. Otherwise, you're going to find yourself in problems, right? It's not going to be an approvable application if you have filed it at the time that file it after overstaying. So if you're in that situation where you've not already overstayed and you're the son or daughter under 21 and unmarried of a green card holder, you're looking at about a 6-month process to a little over a year to get through that process. If you've overstayed, we'll talk about that other process that's called the I-601A waiver process on Monday. But once you've overstayed, you're going to have to look at the waiver process and not adjustment of status. If you're 21 or over, an unmarried of a green card holder, then at that point, if you're in status, your priority date is current. That means they're ready to process your case. You're in status here. You can do adjustment of status. However, if you have already overstayed, it will not work. Right. And keep in mind that green card holder parents cannot sponsor their married children. So getting married disqualifies you from being sponsored by your green card holder parent. Now, there is a process for parents to sponsor their married citizen parents to sponsor their married children. Only citizens can sponsor their married children. It is a 12-year process. So it's not going to offer an easy or quick pathway to permanent residence for any married children of US citizens. All right. So I'm going to go ahead and answer some questions here. So start putting your questions in the comments. I already see a few. So I'm going to go ahead and answer those questions for you. But just remember here that if you're under 21 and unmarried, you have a good shot at still qualifying for the green card within a quicker timeline based on your relationship with a citizen or resident parent, that your process is going to be shorter than if you were 21 or over. Being under immigration, a child is considered under 21, not 18. All right, so let's go here. Um, Now, as a side note, I do want to mention another pathway to permanent residence. What if you're here? You are under 21 and you have a citizen or resident parent, but they're mistreating you. This can also be a pathway for you. If they're mistreating you or mistreated you, then you don't have to depend on your parent to qualify you for permanent residence. You can apply for your own green card through the VAWA process, but it is best that you do it before you turn 21. Now, you at least one of your parents has to be a US citizen or a legal permanent resident for you to qualify for this. And then keep in mind that if you are over 21 years old, but now you're looking back and you're like, okay, but the reason I didn't apply was because my parent was mistreating me. I didn't think I had this option. There is still a chance that you can apply for this relief based on VAWA still, but we'd have to evaluate your facts to determine whether the mistreatment led to the delay in you applying, which in most cases it does, because you're being mistreated, you're in the middle of being mistreated, and you don't think you have any other way. You don't have any other way but this parent, through this parent who's mistreating you. So there's this option as well. If you are experiencing mistreatment by a U.S. citizen or legal permanent resident parent, you're under 21 or you're under 25, we can evaluate whether you qualify for this VAWA option to apply on your own. The parent is not involved in your process, so you don't have to worry about the parent retaliating against you or finding out about this process that you've done for yourself. All right, so let's go to some questions here. Can't a step parent do the filing? So great question. Absolutely. So step parents, let's talk about that. Step parents are also for purposes of immigration law are considered same as parents. But to determine whether the step parent relationship qualifies, you have to look at how old were you as a child when your parent and step parent got married. If your parent got married to your step parent before you turned 18, then that step parent who is a citizen or a resident can also apply for you to gain permanent residence as well. And it follows the same rules as before. So the same rules as I mentioned before, which I know I threw a lot at you. This is where it's important to get representation though, because while I do want to keep you informed, I'm not teaching immigration law 101 here. So if you're in a situation and you want to make sure that you're doing everything correctly, make sure you schedule a consultation with me. But the step parent is also going to qualify here. The same rules apply. If you're under 21, unmarried, and the step parent, as long as they qualify as a step parent under immigration law, the step parent is is a citizen, then you can qualify through, and it's going to be a shorter process, and you could look at overstaying, or if you overstay, you can still apply for this. If your resident parent, you're under 21, your resident parent is the resident is a step parent, they can also qualify but don't overstay. Same rules, right? You, as the child of a resident step parent, you cannot overstay your time in order to qualify for adjustment of status. Now, keep in mind, as I said before, on Monday, we'll talk about the other alternative process if you've already overstayed. We'll talk about that on Monday. What about unmarried child of U.S. citizen over 21 on work visa that filed I-131? Should I go home or stay? So, in this case, your work visa, it may be an H-2B or an H-1B, or yeah, you can let me know if it's another type of visa. But in this case, it's highly unlikely, and I don't know how far along in the process you are. This is where the consultation is going to be very important. However, if your priority date is current, that means they're ready to process your case, and you're here on a work visa right now, then as long as you're not on a crewman's visa, because that's your adjustment of status isn't allowed there. As long as you're not on a J1, that's subject to the 2-year foreign residency requirement, then because the J1 is another common work visa, and some of them do come with what's called a 2-year foreign residency requirement, where it requires you to go back home for 2 years before you can get another status. As long as you're not subjected to those restricted visas, you're here on current status. Now your priority date is current, meaning they're ready to process your petition, then you could do adjustment of status. But if you've just filed the I-130, and now you have to wait out 5 to 7 years, it's more than likely necessary for you to return home and wait there until they're ready to process your case. Because if you overstay and wait here, you're going to find yourself stuck. And it's going to be a very miserable realization and process. So just think, get legal advice. That's the best thing you can do here. But based on the information I've seen there, going home, if you're not ready to apply for adjustment of status, or it's not time for you to do that, you're going to have no choice but to go back home to avoid further complications. Over 21 will have to go back home country for 5 to 7 years during the process. Yes, absolutely. That's what. Now, keep in mind that the facts are different for different individuals. You may have different options, but generally speaking, if you're 21 or over, not over 21, but 21 or over, and you can't stay, you're not here on current status, your process is going to be more complex than you want it to be. So you can't overstay, because you're not going to be allowed to stay here and apply. So what choice do you have but to go back home to wait there? If that's an option. I know for some people it may not be an option. Maybe there are certain different circumstances at home that's preventing you from going back. But if just looking at looking at it from my perspective, at the legal perspective, it's either if you overstay, guess what happens? You're not going to be able to do it through your parent anymore here in the US, unless you do this waiver process that we'll talk about on Monday. But it's not as an easy process as adjustment of status. And if you overstay, you're not going to qualify to stay here and apply. So there's no other choice alternative in that case, unless you have other options. And this is what I do in my consultations, is I not only look at the ones that my clients are thinking about, because it may not even be feasible, but I do look at what options are available for my clients that they did not think about. Sometimes I do identify ways they can qualify, and other qualify, that they didn't that they don't know about. Um, Now, and can I come back to work after going home and starting the I-130 process? So that's a tricky question, because remember that it depends on the type of work visa you have. If you have an H-2B, a J-1, an I-130, and it's not an I-131, but an I-130 petition, is an indication that there's some sort of immigrant intent, that you have the intention to live permanently in the US. Well, guess what? The J-1 and the H-2B require you to have the opposite intent, which is to have temporary intent to live here. And so, if at the deciding officer who is determining whether they should extend your visa, or they should renew your visa, or give you a brand new visa, will take that into consideration, that I-130, as to whether it's an indication of your immigrant intent to live here permanently. So it's risky in that, if you may compromise your visa to work by filing an I-130 petition. That's going to be a risk here that you have to look at. All right, so I'm going to have to look at that bill before I speak on it. So I'm going to do some reading here, and I'll let you know the findings. All right. Hi there, Caroline. Nice to see you. So my C9I765 application is being reviewed at Vermont. They apply fingerprints to the application. 30 days have passed. How long do they take to review the application? So, it could take a while. If this is through VAWA, you could be looking at up to a year. So, the timeline I'm seeing is 6 months to a year. Now, when they say they're currently reviewing the application, it doesn't mean that the officer is like flipping through the pages right this minute, and then any second you're going to get an answer. Sometimes we see that there for up to a year before we see a change. So it usually means like there's nothing that they need from you right now. They're reviewing it and they're going to issue, they'll let you know if they need anything further. So, when you see that actively being reviewed, still don't hold your breath. Okay, so I see I DM'd. I don't answer questions through the DM, but what you will get through the DM is exactly how to get in touch with the office to schedule your consultation. What I'll do is I will go ahead and tell you now how to schedule your consultation. If you look at the bottom of the screen here, you'll see the number. You can call that number and you will get the scheduling coordinator who will be more than happy to answer your questions and help you to schedule your consultation. You can also schedule your own appointment by going to the link in the profile. When you click on the link, and it's also in the link of the description of the video on this YouTube, Facebook, Twitch. If you click on that link, you'll go to a website where you'll see a number of options, and you'll even see some fun options as well. Like you'll see an option to get sample interview questions. So you can look through, see what you can use there that's going to be of value to you there. But at the very top is schedule your own consultation, meaning you don't have to necessarily call the office. You can just get on my schedule. And as soon as you're on my schedule, we do the phone or video consultation, whichever one you indicate, whichever one you prefer to do on the date and time that you select. I do urge you to go ahead and do that if you want to beat the rush, because there are a lot of people that are scheduling appointments right now and the calendar is filling up. So I do want to help you and so I'll have to leave it up to you though to contact us to get started. All right. Thanks for the love. I appreciate it. All right, let's see here. If I file VAWA, can my kids come for the holiday? So, great question. But now, when you file for VAWA, your children can be included in the application. Now, it doesn't mean though that they're going to get VAWA within right after you file. VAWA is a 2.5 to 3 year process. Now, it's that long because you're first getting a special VAWA status and then you're getting the green card right after. So from beginning to end, it's about a 2.5 year process. The children are usually they get it when if they're here in the US with you, they get the VAWA deferred action along with you. But if they're outside of the US, they will be able to come to the US on coming to the US to become permanent residents on an immigrant visa when you get it. So you filing for VAWA will not necessarily affect the children as long as they have the ability to come and see you. Um, it should not affect their ability to come and see you. But I don't know what the circumstances are. But filing for VAWA is not going to affect the children. I know you may have to be looking at other logistical stuff, like if you and your own housing, your own stability, and so forth. But that's more on a non-immigration level. When it comes down to immigration, the kids coming in shouldn't affect. Shouldn't the VAWA shouldn't affect them. How long how long does it take VAWA to be approved? So it takes about 2.5 to 3 years total. So first it's taking about 2.5 years, but in the meantime, you do get your work permit and social security number at about the 6 month to 12 month mark. And so you're able to still work and do what you need to do while you wait for your process to be completed. All right, so that's gonna be it for me today. I don't see any more questions. I will be back. So I'm gonna be back on Monday, and on Monday we'll talk about as if what if you're here, you're 21 or over, or you came across the border without permission, and you've overstayed your time here. How do you get the green card through a parent then? I'll talk about that topic on Monday, right? To talk about the I-601A process. It's an alternative to adjustment of status. And I'll talk about how that whole thing works. All right. So have a good day, everyone. Have a good weekend. Enjoy the holiday weekend, and I'll see you on Monday. Have a good one. Bye bye.